Joining me now is Congress leader and senior Supreme Court advocate, Dr. Abhishek Manu Singhvi. Dr. Singhvi, let's get it clear. The opposition seems to suggest that the CAA is unconstitutional. I had Mahesh Jetmalani a short while ago saying the opposition's entire argument is misconceived. All the CAA is doing what has been promised even by Congress governments in the past, ensuring citizenship for minorities who are persecuted in neighboring countries, especially Pakistan and Bangladesh.
Rajdeep, there are many facets to this, but since you raised one particular facet, let me start by saying that there has never been a law in India, Congress or BJP-led, except this particular BJP brand of politics, nor any other non-Modi party, which has by law, by amendment, by statute, prescribed that you shall have admission to ABCD and specifically leaving out F. Never. Let them point out.
Sir, I will point out. Sir, just a minute. Former Prime Minister Manmohan Singh in the Rajya Sabha in 2003, during the Citizenship Amendment Act debate, said after the partition of our countries, minorities in countries like Bangladesh have faced persecution. It is our moral obligation to seek refuge in our country. Our approach should be most liberal.
You have just started the debate. I have made one sentence. You allow me to complete. You'll get all the picture. All that has happened is, which Mr. Jetmalani is referring to, are administrative or other orders, executive orders, in individual cases, giving citizenship to select communities. What you've done now is something very pernicious and unprecedented. Two facets. Article 14 is the heart and soul of our Constitution. People say, if you ask that question, what is the heart and soul? There are two articles, 14 and 21. Now, it's the first time that a law mandates that all these communities, which you know, the religions, are allowed to apply. One, religion is conspicuous by its absence. One. Two, this is part of a ruling party, ruling dispensation's messaging. When you have not a single, minorities MP from that community or religion, when you have all these statements coming every day, it is part of a messaging. Thirdly, apart from 14, this is based entirely on religion, which is another pernicious aspect of this. And I must ask you, Rajdeep, this was passed more than 3 years ago. Mm-hmm. Can you give me a single reason why in March, a month before the elections, 1.5 months before the elections, there is a hullabaloo about this? This is nothing to do with persecuted minorities. You have the usual arguments. You have so many anomalies. You have the persecuted minorities of Tamils in Sri Lanka. They are not eligible. You have the persecuted minorities of Ahmadiyyas and Hazaras in Pakistan, Rohingyas in Myanmar. The idea is to send a message. I will not even say it's the idea to give or not give citizenship. It's to send a message that we'll put you in your place, we will treat you differently. And for the world's largest democracy, Rajdeep, it is shameful. And never before has it been done by statute. What you are talking about are quotations about people saying, yes, if they apply, we have a mechanism by administrative order, etc.
So you raised certain political points about the timing of this decision to notify the rules. That's strong. Just a minute, sir. That's a political point. I want to focus once again for a moment on the law itself. Just look at the law. According to proponents of the bill, it is a Citizenship Amendment Act of inclusion, not of exclusion. No Indian Muslim is being excluded, is being denied citizenship. We are only including, say, the proponents of this act, people who have been persecuted in neighboring countries, minorities. They've specifically named Hindus, Muslims, Sikhs, Christians, Buddhists, and they're saying we are accommodating them. So it's a law of inclusion, and therefore it is not about excluding anyone or discriminating against anyone.
There are two errors in your formulation, Rajdeep, on the face of it. One, a law of inclusion, which stops short of including everybody in the zone of consideration, becomes a law of exclusion by definition. Mm-hmm. If there are 5 people in the room, same temperature, same house, all more or less the same characteristics, and you say, I include 4, you are excluding the 5th one. Point 1. Point 2, there is no Muslims in it. The argument given is that this community cannot per se be prosecuted or persecuted. That is wrong, because I have given you examples And you see, it was very simple. If it was a secular law, you could have said, this citizenship will be available to all and sundry who apply from these notified countries and notify them properly. The inclusion of a few is the exclusion of the others not included in the few.
So, for example, I asked Mr. Jethmalani specifically about Ahmadiyas, about Hazaras, about also Rohingyas, and also Tamil who may be persecuted. Now, he said,
for example,
do Muslim, he says, do you believe that Ahmadiyas are seen as Muslims necessarily by even Muslims in this country? They've been, in a way, ostracized as a grouping. So, do not equate them with Hindus from Bangladesh who he says have been persecuted and almost at times forcibly converted, or indeed Hindus in Pakistan who've been denied equal rights. You cannot make an equalization between these communities.
Nobody's making an equalization. You are making an unequalization. What is happening is a simple one-line law could have been passed. We want to give citizenship to every persecuted person who applies from the notified countries. That's one modulation. Second is, we want to extend refugee rights, a better formulation actually. We want to extend refugee rights to all persons who seek refugee status from notified countries. A third formulation...
Whether religiously persecuted or economic refugees?
No, the really secular approach would be to say, those who prove that they deserve refugee status, and refugee status cannot be given Rajdeep under the international conventions except for persecution. That's a composite definition of persecution, religious and other forms of persecution. Why don't you make that law? Nobody's objecting. Now let's come to religion. You can make a law of notified countries which includes everybody, does not exclude a particular religion. And this is not about Ahmadiyas or Hazaras. It is about any persecuted religious minority. Of course, there will be a large number of Hindus. We must welcome them. We will welcome them. But why should we not welcome the non-Hindus? So there is a method. The method is to send a message. To say, this is all, you step back. Legislation is part of the promotion of the identity and the policy of the government. This government of the day shamelessly believes that they have a stamp. We are, whether you call it the Hindu Rashtra, we are the pro-Hindu party, we are the only ones who protect Hindus, and everybody else be damned. That is not the identity of a secular country. That is not the identity of our constitution. That is not the identity of 14 and 21.
This government also seems to believe that majority of those who are being persecuted on religious grounds in our neighboring countries are Hindus. And therefore, they deserve therefore special protection privileges in terms of fast-tracking their citizenship.
There is no problem with that formulation, Rajdeep. It could be true in numbers. There may be 100 of those and there may be 25 of the others. We are talking of a statutory exclusion. You cannot make a statute where you draw a line where you say that because this is 60 or 70 people, we will not include the 40. Unless you show that all those 30, 40 fall in a class which is qualitatively different. There is no answer to the point that the others who are excluded are not shown to be qualitatively different, save and except for one reason. They are Muslims. That's all.
Can I therefore ask you in conclusion, Dr. Singhvi, there are about 200 petitions challenging the constitutionality of the CAA pending in the Supreme Court. Now the rules are being notified, have been notified. Where does that leave all the petitioners who went to the Supreme Court? In your view, therefore, is this legal debate now settled simply because politics now has decided that the Citizenship Amendment Act, the rules have been notified ahead of the elections?
I have no hesitation in partially and respectfully faulting the Supreme Court as well, institutionally. Not individually, institutionally. These petitions, the first of them, if my memory serves me right, was filed in 2020.
That's right.
In 2022, an order was passed that Chief Justice Lalit is retiring. These shall be taken up immediately after his retirement in December 22. Now, from 20 to 24 is a long journey of 4 years for a sensitive and a prominent issue like this. We're not talking about whether it's in your favor or whether it's against me. That's not the issue. This should have been decided. That's point one. Point two, I think there is no answer to you about the timing of these rules which you just mentioned. It is unheard of that a law of 19 or 20 is notified by rules. The only reason can be elections. The whole point of this government is keep the pot boiling, keep something happening, show that something is happening. There is absolutely not a single reason given why it is not notified for the last 3 or 4 years.
Okay, let me leave it there, Dr. Singhvi. You're saying the government's intention is to keep the pot boiling ahead of the elections. I appreciate you joining us on our big legal debate here on the Citizenship Amendment Act. Thank you so much.
Thank you.